If you own a property and have a second mortgage on it, and if you want to keep this property and get rid of the second loan, attorney Shaw Parali can help. Call 510-742-5887. Due to the uncertain economy, many people have settled their debts for a fraction of its value. It's recommended to use an experienced lawyer to deal with it. Shaw Parali is an experienced debt settlement attorney and has handled hundreds of such cases successfully. There are no upfront fees for debt settlement. Only when you win, you pay. Call Shaw Parali, attorney at law, at 510-742-5887 or visit yourdebtsettlementattorney.com for a free assessment. This is just an advertisement. No attorney-client relationship is established by this ad. The law does not guarantee success. Call 510-742-5887.
And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shaw Parali for the Shaw Parali Law Show, coming at you with over 50,000 watts of power. The Shaw Parali Law Show, where all your views matter.
Hello everybody. Assalamu alaikum, Sastakar, Namaskar to all the listeners. This is attorney Shaw Parali for the Shaw Parali Law Show, and we are live today, September 7th, 2017. I think it's our first show of the month. And just to let you know, we are covering lots of topics today, including the deferred action for childhood arrivals, DACA, which is now going to be gone pretty much as from September 5th. And of course, there are a bunch of lawsuits, a lot of debates going on, but it seems like now at one point it will be gone. And also we have the frequently asked questions. But before I start, a lot of things happening in the world. First, for people living in Florida, our prayers go to them. Hopefully, the hurricane Irma will not be really kind of hurting a lot of people. It has already hit a lot of people in the Caribbean. And also, we are seeing a lot of issues going on in Myamar, Burma, that I wanted to address a little bit, because this is really something horrible happening. And it seems like it's ethnic violence, and it is very wrong. And the images that are coming from there are horrible. And our heart and prayers go to the people who are suffering, and hopefully there will be a solution. And those who are fleeing, refugees, ultimately will have a safe place, maybe in Bangladesh or somewhere else. And for those living in who are from Burma, Myamar, if you are in the United States, you can seek asylum with the decision if you form part of the groups that are being persecuted. So this is a very important message I wanted to pass. And hopefully, unfortunately, just because it's a poor country, it doesn't seem like a lot of people in the world is caring, but a lot of people also are caring, and hats off to them. So I think we already have callers, Franco, and I have Franco on the board with me. Before I start, anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Like I said, the rules of DACA will be gone now, and there will be, I know there are a lot of callers, so bear with me a little bit, ladies and gentlemen. I'll pick your calls in 1 minute. But I wanted to discuss about many issues. But let me take some callers, and I'll discuss the issues in between. Let me take one caller, Franco. This is Shaw Parali. You're live on air. Hello?
Hello?
Yes, this is Shah.
Hi.
You're live on air. Hi.
Hi. So my name is, I think you said my name is Franco, but it's not. I have a green card application query. So
Right.
my
So we're Frank
sperm application, yes?
Okay. So don't worry.
Can I proceed?
Okay. Go ahead. You have a green card, you said?
So my perm application was approved by my employer, but because of a business need, I have to transfer locations. And now they have not filed for I-140, but since I have changed locations, they have filed for a H-1B transfer with the new location. But I was wondering, since the H-1B transfer is just filed, and before they restart the perm application from the new location, can they, in the meanwhile, file the I-140 and get premium processing done for the previous application? Because I'll lose my priority date otherwise. Is there something like that?
Let me get it right. Are you moving to another company, or you're just changing
No, it's
job?
with the same company. That is why
then it's not a transfer; it's an amendment, right? So yeah, they should file the I-140, and ultimately, if it is, it all depends what are they planning to do in the future. So if they're planning to bring you back to the same location once you get the green card, which is possible, they don't really have to refile a new green card. But if they're planning to move you, yes, then they might have to refile one. And they need to, in order for you to get that priority date, they have to file your I-140. Yes, it is possible, because this is for future job employment, and ultimately you never know, they might bring you back to that location. As long as they have this in mind, possibly, then they can file the I-140. But if they know you will never come there at all, ever, then you cannot do that. But if there is a slight
so it is not tied to the
moving,
H-1B? Like my H-1B is now transferred to the new location.
No, it's not tied completely, because it's for future employment. But there is a chance that they can inquire, okay, you're moving to that, so you're no longer in that place. But most of the time, the I-140 is kind of independent. So as long as they can prove, yes, maybe down the road they will bring you back, then it should not be a problem. But if they already have the intent of never bringing you back, then you have a problem. You need to redo the perm and then file the I-140. But if not, then they can go ahead and file the I-140. Okay?
Okay, that's great. Thank you.
Good luck to you. Let me take another caller, Franco. This is Shaprai. You're live in here.
Hi, Shah. This is Vikas. Shah, I have a question actually. So basically, my last day in the current company was 31st of August, and one of the company has applied for my H-1B transfer. So LCA is still in process, and they will go for H-1B petition in next week. So, but I am getting another offer actually, which is much better and near to my house. So, is it good to have two H-1B transfer parallel? Is there any issue with that?
Usually, no. There are no issues, except if they put different information, then it will be conflicting. For example, because let me kind of go back a little bit. You have 60 days right now with the new law to do a transfer. So you can have transfer with company B, company C, company D, as long as it is done within those 60 days of the grace period. That's number one rule. Number two, if they are filing for you, make sure that they are consistent. For example, one company, look what they are putting in your resume. Make sure that it is the same resume, same information. Like, for example, they cannot put in one resume you work for Microsoft, another resume they put you work for Google, right? So that's where only it becomes a problem. Otherwise, there's no problem to file several H-1B transfers as long as it's within the parameters of the grace period. Okay?
Sure. So if it is still, let's say I start working with the company who is still in process, and the H-1B is not approved, and I join the other company, and their H-1B is also not approved, so that's okay.
Yeah, that's okay, because as long as it is filed within those 60 days, you can move to any of those companies. You can move to B and then decide to move to C. That doesn't matter because it was filed under Section 105 of AC 21, which makes it eligible as soon as you get a receipt to start working for them. The only condition, it has to have been filed within that 60 days from the termination of the job from company A, which is August 31st or something. Okay?
Sure. Thank you, sir. I appreciate it.
Good luck to you. Let me take another caller, Franco. This is Shapra. You're live in here.
Yes, hi, Shah. First of all, I really want to thank you for all your contribution for the society. So this is Prashant here, Shah. So I have a question on H1B.
Thank you so much, Prashant.
Okay. I have a question
Go ahead.
H1B extension, Shah. So recently my employer filed an H1B extension for me, and I got a RFE saying that the RFE says how your education is related to the field that you're working. So that's RFE, and So I'm a mechanical engineer, and I have 5 years experience before coming to US. So based on that, I started in the software industry itself after my bachelor's. So how I have to deal with it? Like I have few subjects, only 3 subjects that computer related subjects that I studied during my.
That's a very good question. Go ahead. What is it?
Yeah. So I have a PG diploma in computer science, for 6 months. But I haven't put it anywhere because it's a PG diploma. I thought I never wanted to put that PG diploma, so I never put it in my resume or anywhere else. So how do I answer?
You need to do what we call an experience credential evaluation. Have you done that?
No, I haven't done it. So I really
so you need to contact
you, and I can just.
You need to contact a company that does I don't want to mention their names, but you can find them online. The companies they will do what we call a credential evaluation based on experience, where they will put focus on the fact that your experience and other areas, basically you have the equivalent of a bachelor's degree when it which is a focus on computer science or in engineering, computer engineering, something like that. So once they get that done, you'll have an expert backing you up, and then the lawyer will have to explain that there's no requirement to have it in the same field as long as you have the experience, which compensate for it. So it requires some writing to do it, but it happens oftentimes. Unfortunately, now it's you have 5 years of experience, so it's a 60-40 probably % of approval. Unless it is done very, very well, then it will be higher chances of getting approved. But I've done many cases like those, and we still get them approved if we have those experts backing us up. It costs some money to do it, around $200-400. But if you have it, it will make your case a lot stronger. And if you need help on answering, just give us a call, and if your company agrees, we can prepare it and handle the case for you. But it's not difficult, but it's not easy also, because you need an expert to back you up. So you need to find those companies online that do credential evaluation based on experience. The big good companies, they will do it, and it will be helpful to make it happen. Okay? So like I said, if you need help, just give me a call, 510-742-5887, and we can handle it. But otherwise, if the company lawyer is handling it, make sure you get that expert letter. Okay?
So before you end up, Shah, I have 10 years experience altogether, so 5 years in India. After that, I came to US on H1B. So in US, I have 5 years experience.
Okay, beautiful. That makes it better for you. Okay, that's great. So just make sure that you get that credential evaluation based on experience, where they will put focus on, because you have the experience, you should be able to overcome that RFE. Because this is something common, but now they're making it more a big fuss. But you can overcome that, because the law says you have to have equivalent, and if you do, then you should be fine. And if we convert the bachelor in engineering that you have, you basically combine your experience to it, and you get an expert to back you up, the case should go through. Okay? Right?
Okay. Thanks a lot, Shah. I'll give you a call to your office. Okay.
Definitely, no problem, and we'll handle it. Let me take another caller, Franco. This is Shapra. You're live in here.
Hi, I had a question on my H1 transfer. I work with company A. So company B initiated my transfer. So while it was in process, I went to India for a family emergency. So I got my H1 approved when I was in India. So I came back to US on H1 of company A, because I have not resigned to the company. So once I came back to US, I resigned company A and joined in company B. So now that my company B is initiating my green card process, now they are saying, so there is some problem with your H1 transfer. So because when it is approved, so you are in India and you came back later, but you are not using this one. So there is some problem in that you have to go to stamping in Canada and do that stamp on your passport.
Yeah, they're right because this is the problem what you did. By leaving the country, you broke the situation of a transfer. What you did is a new employment cap exempt counselor processing. And by coming back again with company A, you never kickstart the 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 H1B for company B. And what needed to be done, at least an amendment should have been filed or another extension with company B. You should have filed it when you came back before you moved to company B, because it never kicked in. So yeah, it will be a problem. You need to take that approval notice, leave the country, and come back. But you might have another problem now because they might say you work unlawfully without your H1B kick in. How long you did work for company B?
I have been working with last 1 year.
Oh, okay. Yeah, this is a very tricky situation because technically you couldn't move to B because B never kicked in. Had you stayed here and the transfer had happened, this would not have been a problem. Even you had come back to work for A because it would have continued on that. By you leaving, you kind of killed the I-94 for company B. And in order for you to move to B, you should have filed an amendment at least or an extension to move that I-94 from A to B. Now, going back to Canada might be is the only Canada or going back outside the country to get a stamp is your only solution at this point. I don't see anything else to fix it from here because you will have an issue because plus you'll have another issue that might come up. You overstayed you kind of violated the H1B for 1 year and why don't you give me a call at the office? Let us discuss in private about this because there's no other solution, honestly, than to leave and come back. But I need more details before you leave so that I can confirm that you should leave or not. Okay? Give me a call at 510-742-5887 and we can do a consultation. Okay? Go ahead. Okay? Okay. Good luck to you. Let me take another caller, Franco. This is Shapra. You're live in air.
I applied for with USCIS for passport for my daughter, but they objected it, saying on the date of birth certificate they are writing. They wrote me that it was registered more than a year later. Registration, I don't even remember that registration might have been done later, or it's clerical error. What can I do?
Where did you apply for your passport? You applied for your daughter's passport? Your daughter is a U.S. citizen?
Yeah. I am U.S. citizen. She is green card holder. She applied for U.S. passport. For her being a minor, she is 13 only.
Okay. When you became a citizen, how old was your daughter?
2 months earlier only. She was same age.
She was 2 months old?
No. She was 14 only. She's 14 now. 2 months earlier, I got my citizenship.
Oh, you just got your citizenship, and you went to apply for her, and they are saying her birth certificate has a problem.
They are saying that the registration of the birth certificate was the registration date on the birth certificate is more than 1 year later than the birth. The birth is 2004, and it was registered in 2007.
Yeah, that's India does that. So it's a late birth certificate. What you might need is an affidavit of birth, couple of affidavit of birth, and then why did you go to the USCIS? Did you go to the passport office or the USCIS?
I got I went to local county and they sent it to a passport agency in Virginia. I got a letter from Sterling, Virginia, from from passport office. Not USCIS.
I need to look at that because technically if the birth certificate is not valid, what they will require is secondary evidence. So what you need to put are 2 affidavit of birth, people who were present at her birth, certifying that she was born on that date, and also any kind of other records that prove that she was born on that date, put all together and submit it. And explain to them in India they made a mistake and they issued a late birth certificate. And if you're having problems with it, then you can contact me and we'll see what we can do. Because this is the first time I get an issue where they give a hard time.
Okay. So me and my wife, both of us can provide them affidavit and with a immunization certificate.
It's better to have some uncles or friends who were there when she was born, from India or in the U.S. who can give two affidavits. Because if you put it
I
yourself,
can get those.
it's self-serving. Yeah, but you can put two of yours too, just to be. Then you will have four of them. So minimum is to have two. Okay. Okay.
So other than that, sorry, can I ask just one for the immunization certificate? That doesn't have mine or my daughter or my wife's last name. That should be okay. We have immunization certificate right from birth, from the date of birth. That should be okay or not? The last name is not. Last surname is not there on there. Daughter's name is
on
there.
where?
First name.
On which
on immunization certificate. On immunization record.
Yeah, that's not important. It's fine. Okay.
Okay. Thank you.
That one is not important because you will need more secondary evidence. It's another is an additional secondary evidence. And if you're getting a problem, just give me a call. We'll see how we can deal with that because usually this problem doesn't arise for minors because India now has fixed their system. So let's see what happens and we'll take care of it. Okay.
I will call them and then I will let you know. I will call you.
Yeah, exactly. Okay. Yeah, ask them if you can provide secondary evidence like affidavit, etc. Okay. Okay.
I will call them and then let you know.
Good luck to you. Thank you. Let me take another caller, Franco. This is Shapra. You are live on air.
Hey, hi, Shah. Thank you. Thanks for taking my call. This is regarding question related to debt settlement. So a friend of mine, his mother-in-law came here, and then she fell down, and then she was admitted to ICU, and they figured out that she was in her last stages of her cancer. Now she was put in ICU for more than a month, and eventually she passed away. Now the bill is about 500K. Is there anything that you guys can help with this debt settlement?
Yeah, but we need to know whose name is on that bill. Is it the name of the mother or is it the name of the children?
Which is better? I don't know. Actually, I don't know that information. But
yeah, if the children sign on it, then they could sign for it. Then we need to negotiate it. But otherwise, if her name only was on that and she passed away and she doesn't have any assets here, there's nothing they can really do about it. But give me a call at the office and leave your number. We'll call you back or call my office and we'll see. But get the document and then send it to us. I'll look at it and I'll tell you if there's a need to even do a debt settlement or we can just leave it like that. Okay? Okay?
Okay. All right. Thank you. Thank you so much.
Okay. Good luck to you. So let me take another caller, Franco. This is Shapra. You're live on air.
Yeah. Hi. Good morning, Shapra Ali.
Good morning.
Yeah, I have a question that my current employer, when I have they did my H1 transfer, and when they did that, they have taken a commitment of the 1 year with the company, and if I'm leaving before the 1 year, I have to pay the expenses of Now I got another opportunity. It is in the still process, but which is more closer to my location. So do I need to really pay the expenses what I have for my current employer?
That's an excellent question. Actually, I have a video on it. There's something called liquidated damages, and there's something called punitive damages. What happens if they put on the contract a reasonable amount, for example, like $2,000-3,000 up to like $5,000? You might have to pay them. You can still negotiate with them, but you might have to pay them because this is a reasonable amount. But if they put an exorbitant amount, like almost $10,000, $15,000, then it falls under the purview of punitive damages. And as such, if a company claims that, there are specific H1B which forbids that. So the question is, how much is the amount? If the amount is reasonable, you probably will have to pay, but you can always negotiate with them, get a lower deal. But if it is exorbitant, then you don't have to pay because then it becomes punitive damages. So it all depends how much money they put in there and how they wrote the contract. Okay?
Actually, they have mentioned as a $10,000.
Yeah, it's kind of heavy then, then it might be falling under the punitive damages. So you might tell them, that's punitive damages, I don't want to pay it. And if they don't agree, just ignore them, because it's not going to affect your H1B. They cannot just because there are specific rules under H1B that you cannot punish someone unless you are some kind of really high line, like a baseball player or some kind of singer. You're very, very unique. They cannot really lock you in most contracts. But it depends on the state where the contract was made. But usually for H1B, that amount seems too heavy. You don't have to pay them that. You can, if you want to kind of settle with them, you can give them a couple of thousand. Otherwise, you can tell them, that's fine. If you want that money, I'll just let the Department of Labor know about it, and let the Department of Labor decide if I have to pay or not. And most of the time, employers don't win on this, by the way. They not only they lose, they end up by getting in trouble. So I think it's kind of too heavy. But having said that, sometimes people don't want to go to that hassle. They just go ahead and give them some money and they leave you alone. But it's not a good idea. I had a couple of cases where they claimed the client $30,000 and the client was ready to pay $10,000, and I said I'm not going to be part of that because they cannot charge money, and we end up by getting zero. In fact, the company got in trouble because that person was blackmailing a lot of people, trying to get the money. So usually, no, you don't have to worry. Just tell them I'm not going to pay. This is punitive damages and it's against the law. And if they keep harassing you or something, you can give us a call and we'll see if we can deal with them for you. Okay? Okay?
Okay, thank you so much.
Okay, and the number for my office is 510-742-5887. Let me take another caller. Yes. Hello, this is Shapira. You're live on air.
Yeah, hi. Good morning. I have a question. I'm currently on L1A managerial visa in the U.S. So I stamped this visa in 2014, and the visa expiration date in the passport is 2019. The petition expiry date is November 2017. So when I went to India for a short trip, a 2-week trip recently, and returned back, I got an I-94 that is valid beyond the petition expiry date. So that is till 2019. The question is, should I file any extension because my petition is expiring in November 2017? Second thing is, if I leave the country after petition expiry date, will I have any problem to re-enter within the visa expiry date?
Yeah, technically L1A and it's usually it goes with what they give you at the airport, especially if it is blanket or something. So
it was blanket.
It might be. It was blanket?
It was blanket petition, yes. So when you look at the I-797, the date of expiry was written as indefinite, right? So that was valid.
Yeah. That's why, because blanket works this way. When you come back at the airport is the one that decide and give you the I-94. So at this point, your I-94 is what controls. So you should be safe here. But I will recommend you double check with the company lawyer to make sure they have all the paperwork right, so that next time when you leave, they don't give you a hard time saying your petition is expired. Because the 797, when it comes to blanket, is important, but it's not that important, because at the airport the I-94 is what controls, but it applies only to blanket. But I will recommend still talking to the company lawyer to make sure they have all the documents right. Okay.
Okay. I have one more follow-up question. My dependent I-94 is I-94 is expiring in November 2017, whereas now mine is still November 2019. So how do I get this extended?
For them you have to file an I-539 for L2.
Okay.
Then they will extend that, and if it is for your wife, if she needs an EAD, you need to file the EAD also. Okay. But file it as soon as possible. You can file it 90 days before. I recommend filing it ASAP. Okay?
Okay, sure. Yeah, thank you.
Okay, good luck to you. Let me take another caller, Franco. Hello, this is Shapira. You're live on air.
Hey, Shah. I have a follow-up question on one of the questions asked previously. That was regarding the debt settlement about the medical bill for somebody who came on visitor visa. So my question is, as per the visitor visa norm, if you provided the certificate of affidavit, is the person who is giving the certificate of affidavit is responsible for the medical bill? Is that true, or is it something they don't come back and request for the money? How does it work?
Yeah, that's $1 million question. It depends on the hospital. If it is a government hospital kind of, then you might be responsible. But technically no, because that I-134 usually applies to people who are taking kind of welfare and things like that. But to answer, unfortunately, most of the hospitals are kind of linked to the government, so they might make you responsible. But they usually don't go into the immigration part. The way it works, what they will do, they will check if you sign. For example, you take your mother to the hospital and they make you sign, right? And once you sign, you're basically kind of taking responsibility of the bill. So we need to look who signed on it. But the I-134 can be used down the road if it is a government hospital or something like that. It becomes under kind of welfare. Then yeah, they can come back after you. But I've never really seen it. Usually what I see are people who sign, because quickly when you're in the hospital they ask you to sign something, you will sign it because you want to make sure the person is taken care of. I did the same for my own family. So, but then the bill, unless you have an insurance, then they will come back to you. But they don't really dig into the I-134 as far as I know, because it's private and confidential. But if it is a government hospital, yes, they can do that. Okay.
For even somebody come here for green card also, for family-based immigration, where you give the certificate of affidavit, is that true for that, or is it both the same?
Yeah, it's kind of the same rule, except it's two different forms. One is an I-134, the other one is 841 or something like that. So it's pretty much you're telling the same thing. You say if that person becomes a dependent or take any kind of benefits, they are eligible to. You are basically liable. Like I said, in my career, I've never seen the government really going after people for that. But the private clinics can come after you for how to put it, for the medical bill. The question is that did you sign, put your social security, etc. Then it can come back and basically go on your credit. But if it is only that person who is sick who signed and they passed away, or they don't have any kind of status, they might not be able to really go after you. So it's very tricky, because we need to know exactly where the situation stands for me to give you a complete answer. So signing the I-134 can become a liability in those cases, depending on the type of hospital you're dealing with. Okay?
All right, thank you so much. I just want to know in general. Thank you.
Yeah, there's no general rule, unfortunately, because people don't even know what they sign when they take someone to the hospital. Okay, so that's a problem. Okay, because you're under stress. Let me take another caller. This is Shapra. You're live in here.
Hi, sir. Thanks for taking my call. And
you're
doing
welcome,
a good service for the community. I have a comment to make regarding the hospital bill. If the person dies and nobody is responsible, and he hasn't signed, nobody has signed the letter. So.
And nobody is responsible unless that person have a estate, right? For example, let's say you die and you have a house.
Yeah.
Then they can go after that house.
Yeah.
But otherwise, no.
And usually the private hospitals, they don't care. So it's mostly if the person is dead, then nobody is responsible. That's what my understanding is.
Exactly, yeah. The state is responsible. You cannot pass a debt of someone on their children unless they're taking over the state, for example, right? So if you inherit something, I kind of...
Because I know a lot of cases like this, and I've noticed that nobody has signed this. So they will send you letters and all, but they won't do anything about it.
Yeah. No, I had a case where they sued the person.
If he's not alive, who are you going to sue?
No, I agree. No, I'm not talking about someone who's dead. I'm talking about someone who signed for their parents.
Oh, yeah. That's a different ballgame, That's a different
exactly.
Yeah.
Oh, you were talking about someone who passed away.
Exactly.
Because then there's nothing to
They will send you the letters, to your relatives or somebody. But if the person is dead, you don't have to do anything. I mean, they always try to get money out of you, But if you are not signed it and the person is dead, doesn't work.
Oh, exactly.
Thanks
so,
for all
yeah,
the
thank
help
you
that you're doing to your community. Bye-bye.
Oh, thank you. Thank you so much for confirming what I just said. Okay, so thank you so much. Okay, let me take another caller, Franco. This is Shapra. You're live on air. Okay, so ladies and gentlemen, we had back-to-back calls today, and I thank you so much. And we have a lot of people who really kind of made our day today. I really appreciate that. And on behalf of the law firm and myself, I wanted to thank you. Thank you for being good listeners. Thank you for always supporting us. I've been doing the show. The show this year reached its 7th year, and we are still going on strong. And we had ups and downs, of course, during the times of all the shows, and also things have changed. 3 governments have changed. No, 2 governments actually, because we started in 2010. We had Obama, now we have Trump, and a lot of things are very different. You know, we had a situation when we started the show. We were fighting only one state, which was kind of. By the way, I started the show basically on Arizona law when Arizona was trying to pass those anti-immigration law, and we wanted to take a stand. And ultimately, we had all those issues with Tri-Valley University, you name it, UNNJ, things coming up. We had back and forth, but luckily, at the end of the day, the show was really helpful. A lot of people would call me, say thanks to the show. I had one person who was arrested, I remember, under the Tri-Valley University, and she said, I heard your show, and you said not to speak without a lawyer, and I did exactly that, and I was able to be out. So these are the kind of things that really makes you feel good having a law show, and I want you to keep listening. And let me take another caller, and then we'll talk a little bit about debt settlements since we kind of jump on the subject next. So this is Shapra. You are live on air.
Hi, good morning, Shah. I have a question about I-140.
Yes, sir. Go ahead.
So if a company has applied for my I-140 and it got approved, and I change the company before 180 days and go to another company and file my I-140, what is the risk of me losing my priority date?
Okay. The question is twofold usually. Are you asking only about the priority date? The priority date doesn't go away unless there's some kind of fraud or misrepresentation. Even they cancel the I-140. As for the I-140, the 180 days applies, of course, if you moved after January 17 when the law was passed, then they cannot cancel your I-140 if 180 days has passed. Even if you have left them before 180 days, but they have not canceled it after 180 days, they cannot really cancel it, okay? But
so if I move before 180 days and they cancel it, and I move to another company, I can still retain the priority date, right?
Yes, the priority date stays with you technically. There is one case law which is not really a good case law, where they refused the priority date when the I-140 was cancelled. But that law was that decision was from BIA, and there are 2 problems with that decision. Number one, they say it's specific to that case; it should not be used for other people. And number 2, the BIA doesn't really have jurisdiction over I-140. So a lot of people got carried away or kind of freaked out because of that case. But you should not. Bottom line, your priority date will stay with you unless there's some kind of fraud or misrepresentation. Okay.
Okay.
Even
One quick follow-up question. If I stay with the company for 180 days, vis-a-vis I change the company before 180 days, does that make a difference in the chances of retaining the priority date, or does it matter?
It doesn't matter. Once it's given, it's given. Okay? Okay. Good luck to you.
Thank you very much. Thank you.
You're welcome. Bye. Yeah, so we don't have any other callers right now, so let me take a chance to kind of cover some other topics. For one, this is a very good question. We got a lot of very good questions today. It's kind of a variety, and I appreciate that because sometimes things doesn't come up to my mind, but when you ask me the questions, I really kind of get involved in it, and I really appreciate because it gives me kind of the trend to talk about issues which are related. For the I-140 that the caller was asking, it's a very important thing that you understand the concept of 180 days. The 180 days is not a requirement to work for 180 days. The concept is they cannot, if they cancel after 180 days, that means let's say you work for 3 months, you left, and they forget to cancel it. Then
7 months later, or 7 months in total, they want to cancel it. Guess what? They can't because they did it after the 180 days. So I just wanted to make that clear. So now let us talk a little bit about debt settlement, because it seems a lot of people are calling, and we got a specifically situation of the hospital bills. This is unfortunately a reality. In America, medical is not free. That's why we have all those issues going on, including the Obamacare, etc., etc. So you need to understand, if you come here and you're visiting, you get sick, unless you have some kind of visitor's insurance, which, by the way, most of the time doesn't really work. Though you won't be able to, you will have to be, that person will be liable. The implication that people ask me, if I owe on hospital bills, will they block me at the airport? Well, in general, no. But recently, I've seen a couple of cases where they did that, exactly that. They went after the person at the airport saying you owe money to a public hospital. So you need to be ready for that, and you might be able to kind of settle those debts. What we do, we negotiate it for you. If you need help, give us a call, 510-742-5887. If you owe money also on credit cards, second mortgages, or you have been sued and you got a judgment against you, we can still kind of help you to negotiate it. And having said that, if you need help, just check our blog, yourdebtsettlementattorney.com, or call us at 510-742-5887. And the good thing with debt settlement, the way we work is on a contingency basis. What it means is, when we get you a deal, then we get a cut for us, or you pay us a cut. So it's like, if we don't get a deal, we don't get paid. So it's very different from immigration, where we take a fixed fee. So if you need help, feel free to call us, 510-742-5887. And before I kind of close the show, I wanted to kind of go over things that I was mentioning in the beginning. We got a lot of callers, so I didn't have a chance to really cover the topic. One, DACA, the famous Deferred Action for Childhood Arrival. That is, sorry for that. The famous DACA is now gone. Now, a lot of people, well, there are some rules now. If you have a DACA which is expiring by March 5th, 2018, you can still file for an extension as long as you file it before October 5th of 2017, etc. But the biggest question that everybody is asking on DACA, people are panicking, calling the office, is what happened to the information they gave to the government? Well, there was a frequently asked questions which we publish on our website. If you type attorneyonair.com or piratilaw.com, you will see it there. What it says is that technically they are not going to use that information. But now there's a glitch there. The glitch is the fact that they have an exception. The exception is if you are a national security threat or a public danger, they will use it. Having practiced immigration law for years, I know that the government can be very wise, well, not wise, but very cunning, and they can convert anything into national security issue, and they can come back and use that information. Now, the next question a lot of my friends and clients are asking, since they are reversing the DACA, are they going to reverse the H4 EAD? Well, H4 EAD was not really passed the same way as DACA. DACA was a direct executive action, while H4 EAD went to the OMB rules. So that means to reverse it, they have to do the same. So it's a little bit different situation, unless you have a judge getting involved and see there's some unconstitutional issue involved, etc. So having said that, then we don't really have to worry about H4 EAD at this point. So if you are eligible for H4 EAD and you want to take advantage of it, still do it. But there is always a grain of salt. There's always issues that might come up. So now, ladies and gentlemen, we have only a few minutes to go. So I wanted to thank you all again for listening. And if you need help on any immigration issue, feel free to call our office at 510-742-5887. And just to let you know, today we discuss about DACA, about a lot of issues when it came to immigration, but at the same time some debt settlement issues. We had some very good questions, and if you want to check more and get updates, I will recommend you sign up. You basically subscribe to our YouTube channel. If you type YouTube/SharpRallyLaw YouTube.com/SharpRallyLaw. This is my new YouTube channel where I pretty much try my best to update it on a weekly basis, including our radio shows. So please subscribe to it. Check our website and like us on Facebook, wherever you think is possible, and you will get updates as much as I can. I try my best to filter things and make it simple for people. So bear with me a little bit and keep listening to the show. Everything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The number to our office is 510-742-5887. Amit, are you there?